Foreign divorce. A foreign divorce can be recognized in the Philippines provided the divorce decree is proven as a fact and as valid under the national law of the alien spouse. The fact that a party was clearly an American citizen when she secured the divorce and that divorce is recognized and allowed in any of the states of the Union. The presentation of a copy of foreign divorce decree, duly authenticated by the foreign court issuing said decree, is sufficient. Given the validity and efficacy of divorce decree, the same shall be given a res judicata effect in this jurisdiction, as an obvious result of the divorce decree obtained. The marital vinculum between the spouses is considered severed. They are both freed from the bond of matrimony. In plain language, they are no longer husband and wife to each other. Consequent to the dissolution of the marriage, the husband could no longer be subject to a husband's obligation under the Civil Code. Maria Rebecca Macapugay Bayot versus the Honorable Court of Appeals. Recognition can be in a separate action. It can likewise be recognized if invoked by a party as a defense. Van Dorn versus Romulo. Santos versus People. February 28, 2018. Divorce between Filipino citizens is void. Second marriage is void. When the first marriage between both Filipinos was solemnized in the Philippines, the law in force adopted the nationality rule to the effect that Philippine laws relating to family rights and duties or to the status, condition, and legal capacity of persons were binding upon citizens of the Philippines. Pursuant to the nationality rule, Philippine laws govern this case, so they remained married until his death, which terminated their marriage. From the time of the celebration of his first marriage until the present, absolute divorce between Filipino spouses has not been recognized in the Philippines. The non-recognition of absolute divorce between Filipinas has remained even under the Philippine Code, even if either or both of the spouses are residing abroad. Hence, the second marriage is void for being bigamous, and under Article 144 of the Civil Code, now Article 148, the property relation between them is governed by the rules on co-ownership. But in order to establish co-ownership, the second wife should prove that she actually contributed in the acquisition of the property. Even under the family code, where co-ownership between them is presumed, there must still be proof of actual contribution for the presumption to apply. In this case, she failed to prove her actual contribution in the acquisition of the subject properties. If the parties have no legal impediment to marry, it is not necessary that there be actual or material contribution because in such a case, there is a presumption that the contribution is equal. In fact, the contribution may only be spiritual. Lavadia versus Ears of Luna. GR 171914, July 23, 2014. Effect if foreign divorce initiated by Filipino spouse. Both Takasin versus Takasin, 625 Phil 494, 2010, and Van Dorn already recognized a foreign divorce decree that was initiated and obtained by the Filipino spouse and extended its legal effects on the issues of child custody and property relation, respectively. The fact that a validly obtained foreign divorce initiated by the Filipino spouse can be recognized and given legal effects in the Philippines is implied from the rulings in Fujiki versus Marinay et al. And Medina versus Koike. In Fujiki, the Filipino wife, with the help of her first husband, who is a Japanese national, was able to obtain a judgment from Japan's family court, which declared the marriage between her and her second husband, who is a Japanese national, void on the ground of bigamy. In resolving the issue of whether husband or wife of a prior marriage can file a petition to recognize a foreign judgment nullifying the subsequent marriage between his and her spouse and a foreign citizen on the ground of bigamy, it was ruled. Fujiki has the personality to file a petition to recognize the Japanese Family Code judgment nullifying the marriage between Marinay and Maekara on the ground of bigamy because the judgment concerns his civil status as married to Marinay. For the same reason, he has the personality to file a petition under Rule 108 to cancel the entry of marriage between Marinay and Maekara in the civil registry on the basis of the decree of the Japanese family court. There is no doubt that the prior spouse has a personal and material interest in maintaining the integrity of the marriage he contracted and the property relations arising from it. There is also no doubt that he is interested in the cancellation of an entry of a bigamous marriage in the civil registry, which compromised the public record of his marriage. The interest derives from the substantive right of the spouse not only to preserve or dissolve, in limited instances, his most intimate human relation, but also to protect his property interests that arise by operation of law the moment he contracts marriage. These property interests in marriage include the right to be supported in keeping with the financial capacity of the family and preserving the property regime of the marriage. Property rights are already substantive rights protected by the Constitution, but a spouse right in a marriage extends further to relational rights recognized under Title III, Rights and Obligations between Husband and Wife, of the Family Code. Republic versus Manalo, GR 221029, April 24, 2018. Invocation of nationality principle is not absolute. Conveniently, invoking the nationality principle is erroneous. Such principle found under Article 15 of the Civil Code is not an absolute and unbending rule. In fact, the mere existence of paragraph 2 of Article 26 is a testament that the state may provide for an exception thereto. Moreover, blind adherence to the nationality principle must be disallowed if it would cause unjust discrimination and oppression to certain classes of individuals whose rights are equally protected by the law. The courts have the duty to enforce the laws of divorce as written by the legislature only if they are constitutional. Barreto Gonzalez versus Gonzalez, 58 Phil 67. As cited in Ten Chavez versus Escano et al. A prohibitive view of paragraph 2 of Article 26 would do more harm than good. If we disallow a Filipino citizen who initiated and obtained a foreign divorce from the coverage of paragraph 2 of Article 26 and still require him or her to first avail of the existing mechanisms under the Family Code, any subsequent relationship that he or she would enter in the meantime shall be considered as illicit in the eyes of the Philippine law. Worse, any child born out of such extramarital affair has to suffer the stigma of being branded as illegitimate. Surely, these are just but a few of the adverse consequences not only to the parent but also to the child. If we are to hold a restrictive interpretation of the subject provision, the irony is that the principle of inviolability of marriage under Section 2, Article 15 of the Constitution is meant to be titled in favor of marriage and against unions not formalized by marriage, but without denying state protection and assistance to live-in arrangements or to families formed according to indigenous customs. Republic versus Manalo. Now, what is the effect if a party is a foreigner who divorced the Filipino? Insofar as Philippine laws are concerned, specifically the provisions of the Family Code and support, the same only applies to Filipino citizens. By analogy, the same principle applies to foreigners such that they are governed by their national law with respect to family rights and duties, which provides that laws relating to family rights and duties or to the status, condition, and legal capacity of persons are binding upon citizens of the Philippines even though living abroad. Article 15, New Civil Code. The obligation to give support to a child is a matter that falls under family rights and duties. Now, since the respondent is a citizen of Holland or the Netherlands, the lower court was correct that he is subject to the laws of his country, not to Philippine law, as to whether he is obliged to give support to his child, as well as the consequences of his failure to do so. In Vivo versus Cloribel, GR 25441, it was said that being still aliens, they are not in position to invoke the provisions of the Civil Code of the Philippines, for that code cleaves to the principle that family rights and duties are governed by their personal law. Example, the laws of the nation to which they belong, even when staying in the foreign country. Article 15 of the new Civil Code. Norma del Socorro versus Ernest Joan Brickman Van Wilson, GR 193707, December 10, 2014. How do we apply this law in the Philippines? Notwithstanding that the national law of respondent states that parents have no obligation to support their children, or that such obligation is not punishable by law, said law would still not find applicability. In Bank of America, NTN-SA versus American Realty Corporation, 378 Phil 1279, 1999, it was said that when the foreign law, judgment, or contract is contrary to a sound and established public policy of the forum, the said foreign law, judgment, or order shall not be applied. Prohibitive laws concerning persons, their acts, or property, and those which have for their object public order, public policy, and good customs shall not be rendered ineffective by laws or judgments promulgated, or by determinations or conventions agreed upon in a foreign country. Moreover, foreign law should not be applied when its application would work undeniable injustice to the citizens or residents of the forum. To give justice is the most important function of law. Hence, a law or judgment or contract that is obviously unjust negates the fundamental principles of conflict of laws. Applying the foregoing, even if the laws of the Netherlands neither enforce a parent's obligation to support his child, nor penalize the non-compliance therewith, such obligation is still duly enforceable in the Philippines, because it would be of great injustice to the child to be denied of financial support when the latter is entitled thereto. Norma del Socorro versus Ernest Johan Brickman Van Wilson, December 10, 2014, GR 193707. So what is the purpose of Article 26, Paragraph 2? The intention of the law is to avoid the absurd situation where the Filipino spouse remains married to the alien spouse, who after obtaining a divorce is no longer married to the Filipino spouse. The legislative intent is for the benefit of the Filipino spouse by clarifying his or her marital status, settling the doubts created by the divorce decree. Essentially, the second paragraph of Article 26 of the Family Code provided the Filipino spouse a substantive right to have his or her marriage to the alien spouse considered as dissolved, capacitating him or her to remarry. The capacity of the Filipino spouse to remarry, however, depends on whether the foreign divorce decree capacitated the alien spouse to do so. Without the second paragraph of Article 26 of the Family Code, the judicial recognition of the foreign decree of divorce, whether in a proceeding instituted precisely for that purpose, or as a related issue in another proceeding, would be of no significance to the Filipino spouse, since our laws do not recognize divorce as a mode of severing the marital bond. Article 17, New Civil Code. Article 17 of the Civil Code provides that the policy against absolute divorces cannot be subverted by judgments promulgated in a foreign country. The inclusion of the second paragraph in Article 26 of the Family Code provides the direct exception to this rule, and serve as basis for recognizing the dissolution of the marriage between the Filipino spouse and his or her alien spouse. Gilbert Kirpus versus Daiselin Chiwal, Santo Tomas, GR 186571, August 11, 2010. Article 26, paragraph 2 is a corrective measure. The second paragraph of Article 26 is only a corrective measure to address the anomaly that results from a marriage between a Filipino whose laws do not allow divorce and a foreign citizen whose laws allow divorce. The anomaly consists in the Filipino spouse being tied to the marriage while the foreign spouse is free to marry under the laws of his or her country. The correction is made by extending in the Philippines the effect of the foreign divorce decree, which is already effective in the country where it was rendered. The second paragraph of Article 26 of the Family Code is based on the court's decision in Van Dorn versus Romilia, 223 Phil 357, 1985, which declared that the Filipino spouse should not be discriminated against in her own country if the ends of justice are to be served. Minoru Fujiki versus Marinai, GR 196049, June 23, 2013. What is the concept of mixed marriage? Paragraph 2 of Article 26 of the Family Code should be interpreted to include cases involving parties who, at the time of the celebration of the marriage, were Filipino citizens, but later on, one of them becomes naturalized as a foreign citizen and obtained a divorce decree. The Filipino spouse should likewise be allowed to remarry as if the other party were a foreigner at the time of the solemnization of the marriage. To rule otherwise would be to sanction absurdity and injustice. Where the interpretation of statute according to its exact and literal import would lead to mischievous results or contravene the clear purpose of the legislature, it should be construed according to its spirit and reason, disregarding as far as necessary the letter of the law. A statute may therefore be extended to cases not within the literal meaning of its terms, so long as they come within its spirit or intent. Even if the marriage became mixed after its celebration and divorce was obtained later after one of the spouses embraced American citizenship, the Filipino can remarry, while the law appears to apply only to cases where the parties must be Filipinos and aliens in order that the Filipino who was divorced will remarry. Yet the Supreme Court said it applies even if the marriage becomes mixed after its celebration. To rule otherwise would be to sanction the foreigners, capacitating him or her to remarry. Republic versus Orbicido III, GR 154380, October 5 of 2005. The next audio will be the solution of marriage due to psychological incapacity, and I want you to do me a favor and hit that subscribe button. It's free. Be a subscriber. Thank you.